Thank you so much for joining us. My name is Walisha Wilson. I'm the founder of New Life Second Chance Outreach. And this month, this is our last actual event that is rounding off our community lunch and learns for our nonprofit organizations in the state of Georgia locally who are advocating for survivors of domestic violence, stalking, dating violence, and all of those great services. And so today we are joined by Tommie, the Cherokee Family Violence Center based out of Cherokee County, but they do statewide services. So tell me, I did not want to mess up your last name, but you are the legal director
Yes, ma'am.
at, and you're going to talk to us about briefly about some of the services, just a summary of the services that y'all serve, but you're going to focus primarily on the legal work that you all help with, and you're going to give us an update on the new Georgia law that protects survivors of domestic violence.
Yes.
All righty. So from this point on, feel free. Go ahead. Thank you
Okay.
so much for joining us.
Sure. And I'm open to questions during my presentation. So as other people join, or if you have any questions, just let me know.
Okay.
So I've been working for Cherokee County for Cherokee Family Violence Center for about over 20 years. And some of the services that we provide are our 24-hour crisis hotline, both in English and Spanish. We run the statewide hotline. If you call the 1-800-HAVEN number and press number 2, that actually comes into our program, and then we can disseminate the information for the county that that person lives in, but that we run the state hotline. We also have a 72 unit transitional housing. It is the biggest in the country, and we are always full, even with 72 units. One of the things that sets our program a little bit apart from others is that they can stay up to 3 years in transitional housing. We have 2, 3, and 4 bedroom apartments. We have empowerment classes that people can attend. So I see about a part of your piece is empowering, and we do that as well. We have the legal advocacy program, which I'll go into a little bit more. We also have the multicultural services. We have an excellent program for children's and teens, both within our program. So people in our shelter and people in the community as well can attend the empowerment classes, can attend the children's program, can attend our support group and things like that. And in addition to the services that I just described, we do a lot of outreach to different agencies, to different municipalities, to law enforcement, prosecution, all that. So we do that. We've been in existence since 1985 is when we got our nonprofit status, and so we've been in the community for a while. Any questions about anything that we offer, the services?
No, I know you said it is statewide, right? You do mainly focus on Cherokee County, but it is statewide.
It is statewide, and in fact, we probably in our housing program, I would say more of them are from outside of Cherokee than they are inside the county. So with the housing, they apply through HUD, and then they're put on a waiting list. And so it's not by county; it's by who's up on who's up on the waiting list next. And
Oh, okay.
so they who's ever up, they get notified. Let me back up. They will apply with our housing coordinator as far as us finding out what their needs are. So it can be a simultaneous thing, but then they get put on the HUD waiting list. But we already have documentation of their abuse, and we can be offering supportive services while they're waiting for the apartment. So we do both.
Okay. And does that supportive services include do y'all have a shelter, or do you have like maybe hotel vouchers or something until?
We do have a shelter. Our
Okay.
shelter is not that big. And it's really, because it's an emergency shelter, it's really hard for them to come into the shelter waiting for the apartment, because the waiting list can be
Very long, yeah.
12 months waiting list. So, and so that's why I'm talking about supportive services. We can help them try to figure out if there's another safe place for them to stay while the waiting, while the list is moving along nicely, hopefully.
Okay.
Yeah, so we work, we just don't say, no, you don't have housing right now. We work with them, we establish a relationship, and there may be other resources that are available at the time of need until the apartment can become available. So,
Okay.
mhm.
Okay. Thank you.
Sure. Any other questions related to any of the services we offer? All right. And our 24-hour hotline is all on all of my signatures. So if you want to put that in
Okay.
anything that you're have going out into the
Okay.
community, great. The part
Oh,
that
one last question before you
sure.
move on. I know the last speaker talked about it very briefly, and we rarely ever hear about it. What's the percentage of men, if any, does Cherokee family violence have had to support and welcome? A lot of folks always think domestic violence only affects women,
Mm.
when 5% actually does affect men. Do y'all have y'all had to work with any men?
Yes, our shelter isn't it doesn't accommodate a man moving in with all the trauma and stuff that um some of the residents may be going through. But so we do have hotel vouchers that
Okay.
we can use until we can get them to a safe place. And then with the apartments, we don't necessarily have abused men in the apartments, we and but we can again find other housing for them until we they can find more permanent or transitional. As far as our department goes, we deal with both men, women, with the legal part. If they need a TPO, we're more than happy to help them with that.
Okay. Thank you
So
so much.
yeah, and same with multicultural department, they will assist men. And I would say you're probably right. It's about 5% that I know that we deal with within this department for sure. For
Okay.
sure.
Thank you.
hmm So what my work mainly focuses on is the legal arena. And so I was just briefly going to go over the different types of protective orders and what they do. Is that something that would interest this group?
Yes.
Okay. So there are three types of protective orders. There's a family violence protective order, there's a stalking protective order, and there's a dating violence protective order. So, because the state of Georgia has sanctioned us, not attorneys, legal advocates, to assist with those are the things that we can provide. That's it. We can't get into divorce or child custody because that would be practicing law without a license, and we are not licensed attorneys. So, we have to be careful about that piece, but we are sanctioned to help them with protective orders. People use restraining orders and protective orders interchangeably, but they are really different. And we can, I mean, they're similar but different as far as what we are allowed to do. So with a family violence protective order, there has to be a relationship. So there has to be either they were living together, are living together, were married, are married, or have children together or related by blood or marriage. So all of those are ors. Okay, not so just one relationship. They can have more than one, but just one. And then there has to be acts of family violence. So that means Georgia has not quite caught up to the emotional and verbal abuse unless it's terroristic threats. So when I say acts of family violence, it mostly is physical. It can be pushing. It doesn't have to be a beating or anything like that, but it does have to be physical or threatening to hurt the other person. That's how you have a protective order. And the other qualification is there needs to be a pattern. So one incident is not enough because what the statute says that previous behavior predicts future behavior. So there needs to be at least two incidences. In Cherokee, the person comes in, we write up their story, type up their story actually in the third person, and then the paperwork gets presented to the judge. With this is the only legal action that you can do where the other side is not heard at the same time. So the ex parte, which means that only one side, is very short. It is no more than 30 days. And so the ex parte gets signed by the judge, and there is automatically a court date assigned to that within the 30-day period. And then in Cherokee, the hearings are done in person in the courtroom, and we don't have a domestic violence court, so we are on the jury non-civil calendar, which also includes divorces, custody, HOA versus blah blah, contract stuff, that stuff. So we're on that calendar, and they they present their case. Sometimes with an attorney, sometimes with not. And we can't help them present their case because, again, that would be practicing law without a license. So, law enforcement definitely encourages. I'm going to use the word victim because usually when we see them, they are in crisis. But it doesn't mean that they're, that I truly believe they are victims and won't be survivors. That's what I'm using for now. But anyways, they will uh, they will encourage them to get a temporary protective order, and we assist them to make sure that it is a good thing for them, a protective thing for them, that it won't make them less safe, because our focus is really on safety. And so and also empowerment. So if they come in and do a protective order and then a couple days later they decide that they don't want the order anymore, we will talk to them about the pros and cons as we see them about dismissing it, but it is ultimately their decision to dismiss it or not. And so, but we also let them know that if down the road they need our assistance, no judgment, we're just here to help. Whatever decision you make at the time is what is good, or is what you think is good for you. So so we are always safety planning with the people that we work with. We Safety planning is very fluid. And so one day this plan may work. They may be able to stay in the house. They may be able to put extra locks on the door, and that may be good. But then the next day something's changed where they're sending people over to bother them, or they're doing other things so they feel unsafe. So then we need to look at those things. So it's very fluid. Um, the other order that we can do is called a stalking harassment protective order, and that is unwanted communication and or putting somebody under surveillance. And the other thing is for no legitimate purpose. So with a stalking harassment, they don't have to have the relationship that they do in a family violence order, but there needs to be a pattern of that behavior. Again, it doesn't have to be an extensive pattern, but it does need to be a pattern. The one thing about stalking orders is that it is still legal to record in your own home. So if there's a number of cameras in the house and one person doesn't want them in there, that's not, it's that they can still be in there because it's still legal to do that. We're working on that legislation, but it's taken a minute to get that done. Same with neighbors. If they're recording another neighbor from their own property, they can do that. They just can't come on the other, they can't come on the other property. So same thing applies with doing the paperwork. It gets presented to the judge. When the judge signs the ex parte, then there's a court hearing that has to occur within the 30 days. And then the dating violence I think that's been in effect for 6 or 7 years now. And the reason why that was developed is that there was a gap because if someone had done something on a date and they never lived together, didn't have children together, were never married, then they wouldn't be able to qualify for a family violence protective order. Well, with a dating violence protective order, it encompasses both the family violence acts as well as stalking. And so so the thing with the dating violence is they have to show that they were in a committed relationship, and it can't be that they were out of the relationship for more than 12 months. So if they broke up 2 years ago, and they wouldn't qualify for dating violence. Depending on what happened, they may qualify for something else, but they wouldn't qualify for dating violence because it's past the year that they were broken up. So and the same thing applies, has to be either an act of family violence or stalking behavior and a pattern. And they fill out paperwork, the judge signs the ex parte, and they have to go to a hearing within 30 days to get it extended for 12 months. In Georgia, it's the ex parte to a 12-month, and then if the person violates during the 12 months, well, most judges look at some kind of need, but you can apply for a 3-year or permanent protective order after the 12 months. You can't go from an ex parte to a 3-year. Some states you can, but not here. So I mean, that's a quick overall of a protective order. Now, what the protection includes is they can't come to the person's house. So if they were living together when the order was obtained, they can be escorted by law enforcement. That's the way the order's written, to get their personal belongings, toothbrush, some clothes, work computer if they have one, those kinds of things, with law enforcement present. Usually it's about a 15, 20-minute escort. They get what they need, and then they can't come back to the house again.
Okay.
Usually. And in Cherokee, we order 500 yards away from the person, which is 5 football fields. So I tell people if they can recognize them, unless they have extremely good vision, they are probably within the 500 yards. So that would be a violation. If they're married, we divide up the cars just to make sure there's no confusion. They at the 12-month, then they can order that the gun removal, or that the sheriff should take possession of their guns and ammunition, firearms and ammunition.
Okay.
So, but there's also provision in there that they can give them to somebody. So I always tell the people I work with, don't assume that they don't have their weapons anymore. I mean, we can take all
Right.
precautions, but you just have to be ready that they might still have their weapons. And there's also other things besides firearms that can be dangerous. Excuse me. So and then custody of the children is usually ordered in an ex parte. Most of the time, we consider it a cooling off period. And when I say we, I mean judges, us, everybody can because again, it's a very short term order. It is no more than 30 days. And on average, I would say it's the ex parte order in Cherokee lasts 10 to 15, maybe 21, but hardly ever 21. But anyways, so the petitioner usually has custody of the children, and there's no visitation during that short-term order. If the children are legitimized, then or because they're married or because there's been a court order, then visitation can be ordered at that 12-month hearing.
Okay.
And so visitation can include supervised visitation. It can include, whatever is in whatever's safe for the children. So, and again, many victims say that they're abusive to them, but they're good fathers. So, I mean, we can spend a whole class on that, but
Mm.
again, we empower the victim survivor to make the best decisions for him or herself on how things should play out. So there is visitation that can be ordered at the 12-month hearing. And then other things that are ordered through a family violence especially is can't trade or sell anything. And then also can't disconnect utilities or anything like that. However, a batterer will find a loophole sometimes. If it's internet, they may consider that not essential. So they may, or they may not disconnect, but they may stop paying. So that would be a contemptible issue, taking them back to court for that. Arrestable would be violating the 500 yards. And then the other protection is no contact, direct or indirect, or through a third party or social media. So if they are contacting the victim related to any of those issues, that is also arrestable. So the contact is arrestable. The not paying child support, not paying utilities is contemptible, which means the petitioner would have to take the respondent back to court to get those things taken care of. When a person violates the order by contact or by coming around, they can be arrested for violation of a protective order, which is a misdemeanor. And if it's a non-violent offense, they are eligible for bond. So they
Okay.
can be arrested for the violation and then out within the next couple of days. If it's non-violent. If it's violent, then they may have to go in front of a judge to get bond, which could hold them longer.
Okay.
So 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 we encourage our people to do what is safe for them. We do talk to them about calling law enforcement, but that may not be the safest thing because, like I said, if it's a non-violent offense, they could be out within, a day or two. They're definitely going to be eligible for bond. For some people, that is, like, oh, I better not do that again. For other people, that's like, oh, you want to do this? It's on kind of thing. And we don't know the abuser as well as they do. So we talk again, safety plan is very fluid. So we talk to them about what they think is going to happen with this situation, with that situation, to help them best figure out their best way for them to deal with what's happening right now. Any questions about any of that?
No, as a survivor who's had to get that, I definitely have gone through the TPO process. I don't think the system that works here in Georgia is one that, to me, really does focus on protecting survivors as much as it should be. I think a lot of it is kind of dummied down, particularly because my abuser actually beat me to it when I
Mm,
was making plans to leave, overheard my
mm,
plans to leave, and beat me to the courthouse and put a restraining
mm,
order out on me, saying that I was the abuser. And instead of the court trying to verify anything, automatically issued their TPO first, meaning locked me out of the house that I was paying all the bills on. They were not
mm,
paying the bills
mm,
because it was a situation of you're not going to leave me, and if you are, I'm going to take everything. And basically, I had to. So even though I was a victim, I was still being traumatized because I still had to pay for rent for several months, utilities, couldn't cut all that stuff off for my abuser.
mm. Yeah,
And so I think
yeah.
Georgia really does need to find some kind of way to look up on the history of the folks who's applying
Mm,
for it, because some folks are really using this
mm-hmm,
PPO thing against what it really should be.
mm-hmm,
Um, because I had never heard of that. I had never heard of the actual abuser because they're unemployed, didn't have anything. I was the breadwinner
Mm-hmm.
going down to get a TPO first. And because of that, I was locked out of my house.
Mm-hmm.
I had to still pay the rent. They had locks changed and everything. And here I was living family to family, living in hotels, trying to get support. And you're just happily living in the house that I pay all the bills on. And that
Yeah.
was according to the TPO. You can't get anything cut off. You can't do this. You can't do that. So I think there needs to be some type of screenings when people are going down there to do that, to say, okay, let's look and see if you've ever called the police. Have you ever done anything? Because we want to verify that you really are the victim.
Mm-hmm.
And in fact, that person was not the victim. It was just a retaliatory way to get back at me for making my exit plan, which some folks say is so safe to do, to make my
Mm-hmm.
exit plan, and it wasn't such a good thing. And so I think at
Right.
that point it needs to be some type of processes in place to make sure, again, abusers are very, they work with your mind and they find ways to get at you.
Mm-hmm.
And yeah, there just need to be some kind of process to make sure that folks are actually doing it, who are actually the people who are being abused,
Mm-hmm.
or if they're actually a person who's the abuser who's doing it to retaliate against other people who want to leave. Because the goal hopefully was, maybe if I do this long enough, she'll drop the TPO and she'll move back in. And that
Mm-hmm.
wasn't the situation. So I think that folks, abusers are actually using the system to further abuse the
Yeah,
victims.
I agree. I agree. We do look in the court system to see if anything has been filed with the other person. We also look to see if the other person has contacted us to to make sure that so we do try to check for conflicts. It takes us a little bit to get police reports, but we usually do um screen. I can't say it's 100%,
Yeah.
but we do some screening before we will assist. But the other thing in Cherokee County, they could file on their own if even if we don't, we say, nope, we're not doing that.
Yeah.
They can file on their own. So, um, and that's nothing we can do about that. And the clerk
Yeah.
has to take things that have been filed. But I'm sorry I had to go through all that. That's
Yeah, it's really
crazy.
bad. And then after that, I did not even know this was in Clayton County. I didn't even know that when you, as a survivor, so a lot of folks ask, why do women stay, or why all these different dynamics play into play, only to find out, having to go through all of this, that it was public record. So
Hmm.
where you wanted, where I was living, where you were, where I finally got situated, was actually in the, I had to literally go and request that my social security number be taken. I mean, that's common sense. People's social security number shouldn't be on public record for anybody to see. My
Hmm.
new phone number, my new address, I had to literally request that. And that's what I was told. That's not something that comes with you getting a TPO. You have to contact the court and request that that be removed. And I'm thinking, that's common sense. Why are you giving people TPOs? And that's being, their new information is being made a part of public record. It doesn't
Hmm.
make any sense, and it defeats the purpose. And it kind of really makes you wonder why a lot of women don't report stuff, because I think a lot of things on the back end aren't made to feel safe, whether it's from law enforcement, who may know the person, that who your abuser is, or, everybody's human as well. They tend to gossip, um, or just the processes of how some people feel about, um, they already have their biases that set in,
Mm.
and just don't, they downplay people's safety. And then people, Lord forbid, people have to leave, and I'm telling you, and I've been begging you, and then they go out and they get killed. And there's this is really nonchalant on it. And domestic violence, I think, is one of the number one killer, particularly with women who are getting killed by guns,
Hmm.
over battering and a lot of other things combined. So it's
Hmm.
like 300 women in Georgia are killed every year from domestic violence. So I really, think this is something that definitely should be taken more seriously, particularly when you're talking about protecting people.
Yeah, I agree. And they did fix that. There is no Social Security in Cherokee anyway. We
Hmm.
cannot submit. Now we can submit Well, actually, when we submit even dates of birth, those are confidential, but we don't
Okay.
submit anything but the last four of the respondent if we have it, and
Okay.
that's on a confidentiality form as well. And even the year of the petitioner's birth is in the petition now, but not the whole date of birth. So
Okay.
anything that has the whole date of birth, and we don't submit full Social Securities, we never did. Then that's on a confidentiality sheet that is not public record. But you're right, there are some things even in the petition you don't necessarily want as public record in the court
Mm-hmm.
system, because there's, some details in there. And I agree with you that there may be a need to seal at least some of it.
Yes.
Having a batter having other people see a batterer's ex parte may not be a bad thing for the general public to know, but
Mhm.
for the details of why he has one, I'm not sure that
Yeah.
the petitioner would want that out there for everybody to see. I
Yeah.
agree with you. I agree with you. Well, we'll bring that up to the legislators because I mean,
Absolutely.
yeah. Um, so let me see. So some of the other things that we do within this department is we definitely network with our prosecution and our law enforcement. We do some training related to empathy and understanding the victim's perspective, because we all know that usually the victim is not calling law enforcement for the person to go to jail. They want the violence to stop. They have never really even thought about, what that next step. They just want the abuse to stop. So we talk to them about that. We talk to them about the cycle, and that sometimes they're ready to, put put the pedal to the metal and, bury that person under the jail. But other times they're not. It's not all bad. And so they go through that cycle and recant and things like that. So we talk to them about those kinds of things, both at the with law enforcement as well as prosecution, because the cycle is still active, whether they're in the system or not. The other thing, as you talked about, was it takes a lot to leave. I mean, there's credit ratings there, all kinds of things that people don't even think about as far as being able to leave and be somewhere safe and, suitable. Um, so we talk to them about those kinds of things, because a lot of times people just say, well, why didn't she leave? Why didn't he leave? And they don't think about, you know, the court being in their lives, maybe defects being in their lives. You have just life going on. You're sick, the children have a cold. I mean, all those things that just happens. You still have to buy groceries. You still have to work. I mean, all those things play into effect. And so we try to help them see that it's just not this one, this 30 minutes in this person's life. There's a whole bunch of other things that need to be looked at to really work on holistic intervention, including that person the person at the table to say, this is what I need. This is the barriers. And I get it. It takes some time to even identify what the needs are sometimes. And like I said, when we work with people, it's very fluid. One minute it's this, one minute it's that, one day it's this, one day it's that. So we work with what s- there it's not necessarily stacked against the victim and their children. It is that it's leaving is like step one, well, really probably step five. And then there's a number of things that follow that. Leaving is not an easy thing. Leaving is difficult. And so that's why we have the transitional housing that's 3 years long, because we knew that my executive director has been doing this work longer than I have, and she knew that 1 year is definitely not long enough. 2 years is okay. And 3 years, at least you have time to exhale the first year, figure out what's going to happen during the end of the first year into the second year, and put your plan into place so that you have some stability. Plus, you know that you can do it, because many victims have been knocked down so much emotionally and verbally that they don't even know if they can do it. And so you have longevity to show that you can do it, and that builds confidence as well. So that's why we have the 3-year transitional program. It's not easy. I'm not minimizing, but it can be done. We have many survivors that have gone through our programs in different departments, and are doing well. We have some that are gone back because of some of the barriers that they endured, and after a while they left again and succeeded, and some are not. They went back and they stayed to make it work to the best of their ability. And some we don't know. That's part of this work too. You don't exactly know what happened to them, good or not so good. So the last thing that I want to talk about, kind of, well, not necessarily quickly, is the Survivor Justice Act, the House Bill 582. Oh, I'm sorry. Any questions about anything that we've talked about?
Nope.
Okay. So this law went into effect July 1st, 2025. And really what it looks at is that self-defense can be now used to as part of an arrest for a victim that really was, for somebody that was arrested as the perpetrator, but they are a victim. So it can be raised as a defense before it couldn't have been. And they may present evidence to show a history of abuse, as you were talking about, and show that some of the reasons why they did the way they did what they did was related to self-defense, or a belief that there was a threat. So that's a little bit different than it was before. You in so let's see. So you can use this it can be expert testimony, which that was a whole different thing. It had to be a licensed therapist, which I'm not saying is a bad thing. I'm just saying that domestic violence experts couldn't testify unless they were licensed therapists and things like that, which that limited some of the access to our victims. So now expert testimony can be given by domestic violence experts. And then also coercion can be used in these cases as well. So some people are arrested because they were coerced into robbing a store, because they knew that if they didn't rob that store, that there was going to be a consequence from the abuser. And so so they were arrested. And I mean, a batterer isn't going to hesitate to set their victim up to, take the fall. Same with, drugs in the car. They know that if they don't take responsibility for those drugs, the consequence, going to jail, is the least of the consequence at that moment. And so now you can introduce coercion into being for the sentencing. So that is a good thing as well. Also, what this looks at is that they can go back. So if someone has already been sentenced, they can be resentenced for different things. And again, they have to petition the court and show that there were mitigating circumstances and situations that weren't necessarily brought out at the original trial because of some of the limitations that were in place before this new law took effect. And so it's, it's not as most of you know, in the legal arena, things do not move fast, but they can move. So, they petition the court and they can have not necessarily a new trial, can't go through all the stuff that was done before. What it looks at is how this new information impacted what happened before. And so they can be resentenced, and the sentence can be reduced, because there are many people in jail right now for a long time that really shouldn't be, because there was mitigating circumstance that didn't come to light because of the old laws. Okay. And then also, now a prosecutor can consent to some of the things, allowing resentencing and those kinds of things. So there's two ways that that can happen. But if you really want to dive deep into the Survivors Justice Act, the Coalition Against Domestic Violence has a whole bunch of information on there that is extremely good. If you know attorneys that might want to get involved, they're always looking for attorneys that want to take these cases. There's a lot of them, or there's several of them. Let me put it that way. And so they need attorneys to take the cases too. And if you know attorneys and you recommend them, we know that they're going to do what they need to do, kind of thing. They get domestic violence, which is important. And then also, they are also obviously looking for witnesses to testify in these cases. So, and I've done some of that as well. And it's a little, it can be intense. Let's just put it that way. As far as doing these kinds of things. But yeah, so I know that was a quick overview about it, but any questions or comments
Thank
about
you.
anything that I've discussed?
No, ma'am, you've been very thorough and I appreciate that. I think there was one comment that said there seems to be so much stacked against victims and their children.
Yeah.
Yeah,
Yeah, I saw the comment. I kind of addressed it. I mean, I guess I might have presented in the glass half empty, but I really
yeah,
am a glass half full kind of person. It just there is a lot of obstacles for victims, and that's why we're all here
yeah.
to help them through it and try to keep them safe.
Okay.
But yeah,
And,
it's
and and I wanted to ask, thank you. It has been very, very informative, particularly with you breaking down the different types of TPOs, because a lot of folks do use them interchangeably. So that was very helpful. But I know when you were talking about the new law, um, did I hear you right when you said is for folks who were coercion, or is that one of the carve outs that they put in is not for
no, no, no. You
survivors?
can. You
Because I
no.
thought show that I read somewhere that said if it was a person was coerced, that they are not eligible to get their charges reversed. So you're saying that it's a person who was coerced is able?
Yeah, it says the coercion statute 1651 is amended in all cases as follows. Individuals can raise a coercion defense in all cases other than malice murder.
Okay.
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 And that they loosened the standards for requiring an action is the only way to prevent death or great bodily harm, replaces it with requires that act was necessary.
Yes, and I think sometimes they should consider that. I mean, there have been a lot of people that are in situations, and unfortunately, some folks did lose their life. But you do not, a lot of folks do not know the stronghold or the mental stronghold and the physical stronghold
Hmm.
that victims have to deal with
Hmm.
when if you're told do this because you already know that if you refuse to comply, what is going to be waiting on you when you get home.
Hmm.
And so I'm glad that was written in there. So if someone is currently inside, they actually the JRP Justice Reform Partnership just had a webinar on it Tuesday on the work that's being done to actually free incarcerated women. And hopefully when that recording comes out, once it does come out, I'll make sure I get that to you as well.
Perfect.
Just to know about that work, because we often see domestic violence victims, are getting arrested and re-traumatized, same as rape victims are as well. And to know that this opening is there made available for them. So I thank you so much for the
Yes.
work that you are doing.
No
And
problem.
thank you so very much.
Thanks. Thank
Yes,
you.
and then Andrea says, thank you about the 3 years of housing allowed by your order. Because most of the time when you hear people do shelter, it's something very temporary. And that's one thing you don't want to hear when you're talking about leaving an abusive relationship. You saying that, oh, I can help you, but I can only put you somewhere for a week, doesn't help someone who has been trying to get a way out. So thank you for that, because I think that's the first I've ever heard of someone saying something about housing being up to 3 years like that. So thank you so very much for that.
You're
Andrea, did you
welcome.
have any other questions?
I think
Okay.
I'm done for now with
Okay.
questions.
Okay.
Well,
Well,
you have my
thank
contact information. If you can post that. I'm usually around.
Okay. Well, I have the information, and thank you so very much for
Thank
joining
you
us.
so
And like I
much,
said,
Tommie.
we're
No
going to
problem.
work on
Thank you.
getting this uploaded, and we'll make sure we send it out to you as well as Andrea.
Thank
Thank you
you.
all so much for joining us.
All right. Bye.
Bye-bye.